So we're very privileged here today to have a good friend Ian Truman, who's a director at Burges, Salmon, specializing in nuclear law, one of our partners. With further to say, I shall pass you on to Ian right now.
Good afternoon, everyone. Jazz, can you hear me?
Can hear you very well, thank you.
Oh, good, excellent. Your lunch sounded lovely until you let up that it was another presentation. Thank you very much. My name's Ian Truman. I'm a director in the nuclear team at Burges Salmon. As a law firm, we specialise in all things nuclear. So the idea today is to run you through the regulation of nuclear fusion, which is, it's fair to say, a developing area. So what I'm going to do is just set the scene very briefly, explain really how the way existing nuclear law works and how that relates to fusion, before moving on to what the sort of main options are for the regulation of fusion. And then really the meat of the presentation is what's happened quite recently in the UK. And as of the end of last week, there was a major paper released by the UK government, which I'll just run through the key points that were raised in that, and then just a few closing thoughts in terms of what's to come. So in terms of scene setting, and this is all stuff that you will all know, but essentially at the end of World War II, following the bombs that were dropped on Hiroshima and Nagasaki, the world really came to realize the potential damage caused by nuclear technologies, and that really had a strong influence on how the nascent fission regimes were regulated from that point forward. That, and of course the accidents that we are all aware of, particularly those the accident at Chernobyl, which have a big bearing on how nuclear fission is regulated. And what's happened is that a dedicated body of international law has developed, accompanied by various sets of best practice documents, a lot of which have been promulgated by the IAEA in Vienna. The primary purpose of all that being protection of people in the environment from the harmful effects of ionizing radiation. And you can see immediately from that high-level statement, referring as it does to ionizing radiation as opposed to fissile materials or anything like that, that there is scope within that for that legislation, at least at that level, to apply to fusion as well as fission. So we're going to move on to look at to what extent this existing fission regime already applies to nuclear fusion, and then compare it to how fission is currently regulated, and look at, as I said, at what's been happening and what's going to happen going forward. Now, I'm not going to go into too much detail here about what nuclear law is. You'll all be glad to know. But I wanted to start just by giving, again, a high level, the definition of what nuclear law actually is. And again, I borrowed this from the IAEA handbook on nuclear law, which is a cracking read. The body of special legal norms created to regulate and conduct the conduct of legal or natural persons engaged in the activities relating to fissionable materials, ionizing radiation, and exposure to natural sources of radiation. So you can immediately see there that is a pretty broad church. It's not just relating to fissionable materials. And the way the IAEA look at nuclear law is you've got a body of special legal norms. So it's a specific regime here. A risk-benefit approach central to managing activities that refers to the principle of justification as well. And you're looking to regulate the conduct of people, companies, etc., etc. And the key here is radioactivity from fission or ionizing radiation. So that is at a very high level what nuclear law professes to be. In terms of the institutions which develop and issue nuclear law, there are really two main ones. I mean, there are lots of other international nuclear laws that come from other places, like the United Nations Security Council, for nuclear security and export controls and things like that. But these are the two I'm going to focus on for this talk. The main one that we're all aware of is the IAEA. And in the slide there, apologies, it's a bit small. I've put an excerpt from the objectives of the IAEA as listed in their founding statute. And again, we can see from that they're there to do all things relating to nuclear energy. They're not just focused, at least in their statute, on fission. And the same with the OECD, Nuclear Energy Agency, based in Paris. We get some of our nuclear law from there, particularly around nuclear liability, the Paris Convention. And again, they're not specifically relating to fission there. So both those parties, as they stand, have the capacity to cover fusion. And that's the message that I'm trying to get across. So if you look at the objectives for nuclear law, we've already touched on this a little bit. It's about a legal framework to regulate those involved in using ionizing radiation, ensuring the principal safety objective to protect individuals' property and the environment. So having a think now about what that means for nuclear fusion. Nuclear law, as it relates to fission, has developed, as I mentioned, because nuclear energy is considered to be unique. And what's flowed from that is a series of principles. And there's a long list of principles listed in the IAEA handbook on nuclear law. Things like the permission principle. You can't operate a nuclear power station without a license. The continuous improvement principle. Lots of different principles and sub-principles based on the catastrophic nature of a nuclear accident and really driving towards the very stringent regulatory regime that we all know applies to fission. But to what extent do the risks posed by fission fall into the same category? Are they really unique in the same way as those that relate to fission? Do they really have the same pose the same potential for catastrophic outcomes? Fusion cannot cause the same a nuclear meltdown in the same way as a fission reactor can. Fusion doesn't create high-level waste, no spent fuel rods coming out of the fusion reactors. And fusion reactors are considered inherently safe. So is it really justifiable and proportionate to regulate fusion in the same way? That's really the million-dollar question. The basis on which the IAEA regulates nuclear fission comes from this concept, which we call SSL, which is essentially the interface between safety, security, safeguards, and liability. And you can see from the diagram there, where all those cross over, that's where you have the liability arising. And of course, we all know they're very closely interrelated, and particularly security and safeguards have been coming together in terms of how they're regulated in recent years. But that is really the foundation of how fission is regulated, or at least at the high level on the international stage. When you look at the actual existing international nuclear law, now some of you won't be familiar with these. I mean, this is essentially the international law. In the UK, we implement our own legislation that makes sure that the UK complies with what's in these international laws. Convention on Nuclear Safety, you will all know very well. That applies to nuclear installations. And if you read all the definitions in that legislation, it starts to talk about fuel assemblies and fuel rods, and it's very clear. Whilst it doesn't exclude fusion, it's very clear that you look at the dates of it, it's very clear that it was intended to apply to fission, because that's all that was really on the table when the convention was being negotiated in the early 90s. And in fact, it was a previous IAEA safety standard that got sort of converted and upgraded into a convention. The Joint Convention on Safety of Spent Fuel Management and Radioactive Waste Management applies to all radioactive waste. So that is a more likely to apply to fusion, in that fusion will still generate radioactive waste, albeit at a lower level. As I just mentioned, we're not expecting any high level waste to be generated. Convention on physical nuclear material, this is about purity predominantly. Again, applies to materials, the definition of which is relating to fissionable materials, fissile materials especially, exclusively. You then have the NPT, the Non-Proliferation Treaty, which establishes the sort of international law regime for nuclear safeguards. And again, that applies to special fissionable materials as defined by the IAEA, which certainly doesn't include anything that you would expect to find in use at a fusion power station. You then have safeguards agreements. Now, under the Nuclear Non-Proliferation Treaty, non-nuclear weapons states have to enter into comprehensive safeguards agreements with the IAEA, and nuclear weapons states, at the time the treaty was entered into at least, volunteer to enter similar agreements. So they have what we call voluntary offer safeguard agreements, which many of you might have heard in the news around Brexit, because we had to agree new ones as a result of our leaving the Euratom community. And additional protocols agreed further to these safeguards agreements. All of those two sets of agreements do not apply to dual use items such as tritium. Now, what dual use items is a sort of term used in export controls, whereby it's not only the really obvious stuff that you have to worry about exporting, like, you know, parts of a nuclear reactor. It's stuff that could be used for something else, or that is used for something else, but could also be used as in a nuclear reactor or a nuclear device, because obviously the main aim here is to stop this equipment falling into the wrong hands. When these were negotiated, however, there was discussion as to whether tritium should be included, and I think that is because of the potential of the military side. But so far, certainly, tritium has not been, as far as I'm aware, included as a safeguarded material. The Paris Convention I mentioned at the bottom there, I mentioned this earlier. This is the OECD legislation that governs nuclear liability to all the signatory parties, including the UK. Its full name is the Convention on Third-Party Liability in the Field of Nuclear Energy. Most of Western European states are signatories to that, and that is where we get the concept of nuclear liability, so absolute liability for an operator, fixed or capped at a certain amount, and an obligation to have third-party nuclear liability insurance up to said limit of liability. And this concept really that it's all about getting compensation to victims of any accident as quickly and smoothly as possible. So that is what we have in terms of what I call hard international law, which is really, you know, conventions, treaties, that sort of thing that we all recognise. But there are other sort of agreements which didn't start off as necessarily law in that sense, but have developed and become what we call customary and international law, because they've been adopted and they're now essentially ubiquitous across the global nuclear sector. And one important one here is export controls. So Nuclear Suppliers Group is a group that of as the name suggests, the major nuclear supplier countries, and the aim there is to make sure that nuclear trade doesn't result in the proliferation of weapons, and this is sort of what I alluded to with the comment on dual use items. So they've issued two sets of guidelines, one for sort of direct nuclear transfers, so that's the really obvious stuff, and then for another part two for transfers of nuclear related dual use equipment, materials, software and related technology. Now, in this use of dual use items, tritium compounds and tritium facilities are listed. So what this means essentially is that states that are members of Nuclear Suppliers Group, including the UK, are obliged to make sure that export controls are applied to tritium compounds, and tritium facilities. So where you're exporting those items from the UK, you will need an export control license from the export control joint unit. And that is essentially because of this concern that the tritium can be put to military use. So these guidelines form part of the UK strategic export control lists and are incorporated into UK law through that route. So the other aspect I wanted to touch on was radiation protection. Internationally, radiation protection comes from ultimately the process on the screen here. It starts with essentially scientific findings from the United Nations Scientific Committee on the Effects of Atomic Radiation, I think it stands for, which are then developed into recommendations by the ICRP, which is probably more familiar to both of you, and they in turn form the basis of the IAEA Basic Safety Standard, International Basic Safety Standards, which are reflectable until before Brexit were the basis of the Basic Safety Standards Directive adopted under Euratom, and since Brexit will be implemented directly in the UK through instruments such as the ionising radiation regulations. So that, and I've included that obviously because radiation protection, as the name suggests, is applicable wherever there's work happening with radiation. So it doesn't necessarily distinguish between fission and fusion. So just a very quick outline. I've alluded to some of this already. So you have the international treaties and bilateral arrangements between countries and between countries in the IAEA, which are on the bottom there of the pyramid. You then have national laws in the UK. Because of our legal system, we have to implement international law into the domestic law for it to take effect. So our principal nuclear legislation, things that people have probably heard of: Nuclear Installations Act 1965, Environmental Permitting Regulations 2016, which contains a schedule for radioactive substances activities, and Ionising Radiation Regulations 2017, as I just mentioned, which implement the IAEA International Basic Safety Standards into UK law, and REPIR, which is around emergency preparedness. You then have a regulatory regime on top of that. In our case, you're talking about nuclear site licensing, or licenses, license conditions, management arrangements, environmental permits, and then above that you have regulatory guidance. So here we're talking about ONR, TIGs and tags, and safety assessment principles and security assessment principles, etc. So that's broadly how the system works. Moving on to how JET is covered. At the moment, JET is regulated under the Health and Safety at Work Act. It is not a nuclear installation or a nuclear licensed site under the Nuclear Installations Act 1965, which is an important distinction. So all it has at the moment in terms of regulation is the obligations under the Health and Safety Work Act to do all as far as is reasonably practicable to ensure the health, safety and welfare of your staff and those you affect. And then under the environmental permitting regime, an RSR permit under Schedule 3 for conducting a radioactive substances activity. And questions here about whether this will change for commercial scale fusion and whether the UK should follow ITER in volunteering for the nuclear fission regime. So very quickly on the UK fission regime, currently you require a license if you're using a site for any nuclear reactor or prescribed installation. The definition of a prescribed installation is basically set, or prescribed installations for this purpose are set out in the Nuclear Installations Regulations 1971. And one of the things there that requires a license is the storage of bulk quantity of certain materials, and the ONR established that is 100 times the Schedule 2 REPIR values. And there is some question as to whether the tritium inventory on a fusion site will actually trigger this requirement. So options for future regulation of fusion. We can stay where we are, do nothing. We can go to the fission regime where we're governed by ONR and EA, or we could come up with a brand new regime with a new regulator. Some of the factors we need to consider here, proportionality, this is really the biggest one. Are the risks posed by fission, do they really justify the level of regulation that we see in the fission space? Perception and trust, that's a factor. Will the public understand the difference? There was a survey recently, 40% of the British public didn't even know what fusion was. So there's going to have to be a big PR campaign if we are going to pursue the commercial development of fusion based on the current regime, which isn't regulated as a nuclear site. Lessons learned and understanding. How will the STEP project, the UK AEA's commercial scale reactor, differ from JET? Will the size and scale of it mean that more stringent regulation is justified? And then some points here about how those areas are regulated and whether we want to be enabling in terms of this sector. So key developments in the UK, we have a Regulatory Horizons Council report which set out how they thought that that fusion should be regulated in the UK. A recent EA consultation on whether they should extend their charging scheme to include fusion activities. So this is the capacity to agree with the EA for support and essentially the EA being able to charge for that. And what I really want to focus on in my remaining time, the recent BEIS consultation on a regulatory framework for fusion energy. So the BEIS consultation essentially concluded that we should maintain the existing approach, i.e. using the Health and Safety Executive and the Environment Agency. But they did also say they wanted to clarify existing regulations as to how they might apply or not apply to fission and introduce new provisions. Now, what I assume they're referring to here is things like that point I raised around the tritium inventory possibly triggering that threshold of bulk quantities and therefore the requirement for a license under the Nuclear Installations Act. So presumably BEIS are proposing here to close that loop and either completely carve out fusion installations from that regime or tweak the wording somehow. Enhance engagement and develop new guidance, as we'd expect, that will be required, and keep those policies under review. So further key points taken from this paper, which is still open for consultation. Fusion reactors will require justification, which I think is to be expected. There's still practices that have to be, and we have to demonstrate that the benefits of those practices outweigh any possible detriment they might cause. NIA 65 to be amended, which I've already mentioned. A fusion national policy statement under the overarching national policy statement. This is around planning and the development consent order regime. So essentially, there'll be sites listed in there that are considered appropriate for development of fusion. Third-party liability regime. The government at the moment is considering adopting certain principles of the Paris Convention, which I mentioned before, but is still left a few things TBC, and notably the level of liability and how long the liability period will be, and that strict liability will last. Cyber regulations still need to be dealt with, and the government's going to come back to us on those. It's talked about early engagement and encouraged that, but stated that will not be compulsory. It's going to issue additional regulatory guidance. It's talked about the UK AEA's Fusion Safety Authority providing services to the regulators. It's talked about the Committee on Radioactive Waste Management advising on how fusion waste is to be managed, but suggests that existing policy and strategy is good. So there's a question there about whether fusion plant will require a funded decommissioning program or not, for example. It's confirmed that safeguards are unlikely to apply, export controls are likely to apply, which I've already mentioned, and that it will review this regime every 10 years. And there's a need here to focus on international collaboration, and this is really one of my key closing thoughts. Along with the liability piece and what scaling up fusion is going to mean, one of the big questions I think is what is happening internationally, because whatever we do in the UK, if the IAEA, for example, then come and adopt something that's fundamentally different, then we're going to be under tremendous pressure to change the way we regulate fusion. And if a project's already started on the basis of what it thought was the regulatory regime in the UK, that could be extremely damaging. So there's some work here to do to make sure we're harmonised with what's happening elsewhere. So I'll stop there for questions. Slightly overshot, so apologies for that.
That's brilliant, Ian. Thank you very much for that presentation. Bring us all up to date on fission and fission law and where it's heading for fusion. Must say, I did like the pyramid, which really was a nice, clear way of explaining from an international standards being developed, international law being brought into home law, if you like, and then how the licensees develop that, and we communicate with the wider public. I suppose the question I've got is, in the whole discussion piece around fusion and fusion regulation, the Office for Nuclear Regulation wasn't mentioned at all in that presentation. Now, is that because, if I let you come in there, or is that because there is a desire not to overcomplicate regulation in this particular area?
Well, I think it's a combination of factors. So initially, and a lot of this is secondhand, that people have told me. Initially, the ONR didn't seem to be that interested in regulating fusion, and certainly there was a settled aim that fusion shouldn't be regulated in the same way that nuclear fission was. I think industry was concerned that if ONR did take it on, it would inevitably shift towards the fission regime, given that's what ONR were so accustomed to. But certainly throughout the process, certainly in the Regulatory Horizons report that I mentioned in my presentation, ONR were contributing to that report, certainly making noises that they were more inclined to get involved. And so they're certainly more interested than they were. But I think it's fair to say that as an industry, those involved in fusion that I've spoken to certainly are very clear. They think that fusion is a fundamentally different proposition and should therefore be regulated more like a complex industrial facility than a large nuclear fission plant.
No, that's understood, and that I think is where we probably are heading. It's interesting that in France, as you know, with the ITER project, it's regulated by ANS, which they've taken a slightly different approach there because of the probably larger scale site, first plasma coming in 2025, etc.
There's a few points there. I mean, firstly, that's a true international collaboration as a project. It's global nuclear countries getting together and doing that project, and it started very, very early. And the ITER organization, actually engaged and decided they volunteered and actually offered to the French authorities to be regulated under the fission regime, because I think they didn't really know what to do with them, to be honest. But they volunteered for that, and there was a risk that everyone then just slipped in behind that and followed suit. And I think certainly people in the UK sector have been, reluctant to do that and wanted to sort of make a clean break, as it were, to a different way of thinking.
Understood. I've got a couple of questions coming in, and the first one is to do with the GDA, generic design assessments. Would fusion, is there talk of fusion technology having to go through some form of generic design assessment?
Not specifically that I've seen. There have, obviously, I referred to sort of early engagement with regulators that is being encouraged by the government. They haven't gone as far as to say that they think that should be a formal GDA process. And obviously at the moment that is run by ONR and EA, who might not have the capacity or the regulatory function to do fusion as we go forward. So there's a question as to whether we have a GDA-like process that is run by experts within HSE, or new expertise that's developed and sustained within HSE, or whether there is some sort of technical service organisation provided from the UK AEA's Fusion Safety Authority that will help with that, at least initially. So I haven't seen anything either way on that, either including it or excluding it. But if you look back at the purposes of GDA at the beginning, it was to try and help out the poor old planning inspectors who were having to try and decide if a reactor design was safe or not. So I would see that some of those drivers would equally apply to fusion, and certainly, I mean, GDA is a long and expensive process, as you all know. Whether there can be a sort of sensible adaptation of that process for fusion remains to be seen.
Fair enough. Just a quick observation from my part, based on you know, what you've summarised there. There seems to be still perhaps a long way to go in terms of pinning down exactly what regulatory regime, perhaps from a UK perspective, we may end up in. You could argue we probably need to get there sooner, so that gives investors confidence in terms of manage their risks in these sort of technologies. Although we say they're you know, years away, but you know, money needs to be generated now to invest in them. And then my final question is, and it's a quick one, is the $1 trillion question. When do you think the first commercial fusion plant will be plugged into the grid?
In the UK, at a commercial scale, 2040. That's when the STEP reactor is programmed for, and that's my diplomatic answer.
Thank you very much for that, Ian.
But as you mentioned, there is a long way to go on the regulatory side, which is just one piece.
That's brilliant. Thank you very much, Ian. Much appreciated, and thank you very much for your time supporting the forum.
Thank you very much for inviting me.